class, Get Closed, Get Paid. Today's discussion will be on credit, gifts, and rebate rules in real estate transactions here in Florida. And my name is Erin Miller. I'm a real estate attorney, and we have the lovely Kristen Jaiven. This is our fourth class that we've done in the series. It's our last class for 2023. We're both pretty excited about winding down and then gearing up for a fun list of classes in 2024. Before we dive right in, I do have some housekeeping notes. This is my attorney disclaimer and our antitrust reminder. We are attorneys, but anything we talk about here is for educational purposes only. We are not giving specific legal advice for your situations. Everything that you deal with in the legal world is fact specific. So if you would like legal counsel, please consult an attorney for your specific situation. And of course, the attorneys here are not expressing the opinions of any committees or organizations on which we serve. They're just our opinions. And of course, the antitrust statement is due to the nature of our conversations and the world that we're living in right now. We want to make sure that we are respectful of the antitrust regulations, and we are pro-competition. So keep that in mind when we're having our discussions. And let's dive on in today. So our topic, of course, is credits, gifts, and rebate rules in real estate transactions. We're going to talk through some credits in our sales contracts. Specifically, we'll talk about compensation agreements and rebates, and we'll dive into the kickbacks and rebates rules. And we'll have an open discussion on when perhaps it might be appropriate for someone to receive a credit in a real estate transaction. And we'll dive right in. So I'll talk about the credits and the sales contracts. And again, when I'm talking about sales contracts, typically we're talking about the Florida Realtors Florida Bar or the Florida Realtors CRISP contract. When we're talking about our credit and the sales contract, those can arise in a number of situations. Typically, if you have a buyer who knows they need some assistance with getting maybe their down payment covered, their closing costs covered, they will, in their initial offer, request a credit in other terms and conditions or in an addendum to contract. Seller shall provide a credit to buyer in the amount of X dollars at closing towards closing costs and prepaid. I want to reiterate that in the sales contract between a buyer and the seller, the request for a credit is between the buyer and the seller. So the only two parties who can offer a credit to each other are the parties who are signing the sales contract. Other times the credits will come up will be in an inspection situation. I know throughout the state of Florida, most folks use the FAR bar as-is contract. Of course, an as-is contract doesn't necessarily mean the buyer is going to accept the property in its as-is condition. They typically request something, whether it's repairs or a credit towards maintenance items, a credit towards the closing costs. Some sort of credit will be requested. Now, the document to request that credit is the appropriate document is an amendment to contract. I'm saying amendment, but I know that the form that is available for Florida Realtors is an addendum to contract. It is a blank addendum. And the concern, of course, that we as attorneys have is we don't want realtors crafting legal language and having their parties sign it. We know that it's perfectly acceptable for realtors to fill out the blanks in the Florida Bar Florida Realtors forms, but we don't want you to craft some fancy legalese and put it in an addendum to contract, and then this could have some real consequences for your customers. But a credit at closing or credit towards closing costs is a pretty simple one. And if you'd like a sentence or a clause, you can always request a sample from your broker or from an attorney, but typically the language is something like seller shall provide a credit to buyer, right? The who, seller providing credit to buyer in the amount of X dollars towards closing costs and prepaids or whatever the credit is for. If you have a cash transaction, the credit really can be towards anything, right? It could be towards a roof replacement. It could be towards radon mitigation. It could be to repair the fence. And you can be specific if it's a cash transaction. If it is a loan transaction, however, lenders don't really want to hear about inspections, repairs, things like that. But they are willing to allow a credit between a seller and a buyer up to a certain amount for closing costs, prepaid, discount points, and that kind of thing. So essentially your credit is just a reduction in the amount that the buyer would have to bring to closing for their property. And there are limits to what a lender would allow based on the type of loan that the purchaser is getting. If you're getting financing and the amount that they're putting down, there are certain limits on how much of a credit that the buyers are able to receive. I would check if you're going to consider including your credit, whether in your initial offer or as an addendum to contract when you're mid-transaction. Consult with the lender who's providing financing and ask, what is the limit? We want to make sure that we're structuring this in an appropriate manner. But if you have an addendum to contract or halfway through your transaction and you would like to make a request of the seller to provide a credit, let's say you're in your due diligence period and the buyer would like to request a credit of $5,000 from the seller. You want to make sure that that request for the credit is executed within the due diligence period. We know during an as-is contract, the buyer has the right to make requests for inspection items or credit during that due diligence period. After that due diligence period, however, if there is no fully executed addendum to contract, then the buyer is accepting the property in the condition that was in without any of those credits. You want to make sure that you get those credit addenda amendments executed within that due diligence period. And we're going to jump into broker compensation in the farmer as-is contract, but I do want to highlight something that appears. So this is really the spot where we look at our language regarding broker compensation. And it's clear, the very last line, 643 and 644, says the contract, the sales contract between the buyer and seller shall not modify any MLS or other offer of compensation made by the seller or listing broker to cooperating brokers. So we're going to rewind where I said the sales contract is between a buyer and the seller, and the buyer and the seller are the only ones who have the authority to bind each other in that sales contract agreement, which is a very long-winded way to say that buyer and seller cannot modify the compensation that's offered either to the MLS or the compensation that is being offered by the listing broker. So buyer and seller, though they may try to put in other terms and conditions what they want the broker compensation to be in that sales contract, that is not the appropriate avenue to do that. As an aside, when we as closing agents, title attorneys, law firms are requesting the verification or broker commission verification, we're going to send either a link or a piece of paper for the brokers to complete to identify how much they're expecting as far as broker compensation. And we're also going to start asking the question of, and who is going to pay it, right? So it is typical up until recently to have many of our transactions, we just assume that the broker compensation is going to come from the seller's column on the settlement statement. So that is no longer going to be the presumed method. We're going to ask the question, how much compensation is your brokerage expecting and who is paying it, whether it's coming solely from cooperating compensation on the MLS, or whether there's a separate buyer-broker agreement by which a buyer has agreed to pay a certain amount of compensation to their own broker. So just as we kind of jump into 2024, make sure if you're using buyer-broker agreements, you're providing that information to the closing agent so they can allocate appropriately the fees that belong on the buyer's column of the settlement statement and the fees that belong on the seller's column. And this clause in the at the last page of the as-is sales contract, again, lists the cooperating sales agent, cooperating broker, listing sales associate, listing broker, and it says to the closing agent that seller and the buyer direct the closing agent to disperse the full amount of the brokerage fees as specified to these particular brokers. So make sure, again, this information is accurate, your name's accurate, the brokerage is accurate, and that is the directive to the closing agent to disperse broker compensation. All right, that was my mini little soapbox. All right, Kristen. Oh gosh, tell me what we need to know about compensation agreements generally and how rebates can happen. We already talked about how they can appear on the sales contract because that's between the buyer and the seller. The brokers are not a signatory party to the sales contract. So what do we do here?
Okay, so if we want, do we want to pop over to the rule for it first?
Yeah, let's go to the rules.
I think that's next slide.
Okay.
Okay, So generally, Chapter 475, as everyone knows, you can't collect commission for providing real estate services in the state of Florida unless you are a licensed real estate agent and your license is affiliated with a real estate brokerage office. There is an exception to that rule. It's not in Chapter 475. It's actually in the Florida Code, the rules that implement Chapter 475. And the rule is quoted here. So it's 61J2-10.028, and it regards as it's the kickback and rebate rule. And it says any real estate licensee who receives or makes arrangements or agreement to receive directly or indirectly any kickback or rebate for the placement of or in favor of any business transaction, which is formed part of or incident to the transaction negotiated, is a violation of Chapter 475. So this is the anti-kickback rule for brokers. And then part two is the sharing of brokerage commission by a licensee with a party to the real estate transaction with full disclosure to all interested parties is not considered a violation of Chapter 475. So what that means is that there's really two categories of people who can receive real estate commissions in the state of Florida. Either one, you're licensed, properly licensed, properly active with a broker, or two, you are a party to a transaction and you are receiving the commission from an agent in the transaction and it's being rebated to you in the specific transaction. So why is that an exception? I haven't reviewed the statutory history on this, but it does make sense. If you are paying someone for services, whether you're going to the store and buying goods or you're hiring an attorney or someone to paint your house and provide services, there's situations where you might need a refund or you might need an adjustment on the compensation paid. This allows that to happen. So the sharing of brokerage compensation by a licensee with a party to the real estate transaction with full disclosure to all interested parties is not considered a violation of Chapter 475. The key to this is that all interested parties have to be notified. Best practices in accomplishing this is to do a broker letter. For one, if you're an agent, you have to have your broker approval. You can't just authorize it as an agent. The broker is going to have to sign off because it goes through the broker. But the best part is to have a broker letter signed by the qualifying broker of the entity that says, I'm going to compensate my buyer in the transaction X amount of dollars towards closing costs. You can also do a commission credit to sellers. Though I think more commonly what I see is not so much a commission credit, but a commission reduction on the listing side of the transaction. So instead of compensation going in, it's just saying, Mr. Seller, I'll reduce my amounts. But if you're providing an actual credit, it's going to show up on the HUD. It's going to end up in Erin's desk as something that needs to be accounted for at the closing process. Then you need to make sure a letter goes out to all interested parties. So all interested parties, who does that include? I would say it includes both parties to the transaction, the title company, and if there's a lender involved, definitely the lender. The lender, it could impact lender. There's certain ratios of how much credits can be done. So you've got to get the lender involved in case you do too much. So I always like to give examples from my own home purchase because I think I ran into every issue available. When we purchased our own home, we tried to do a commission credit. My husband's a broker, but we already had a roof credit from the seller due to an inspection issue. And those two credits made it through regular underwriting, got clear to close, the transaction closed, then it got kicked back after the secondary review person, which is the only time I've ever seen this happen. Of course, it's my house, and we had to go back and readjust everything because it was too much credit. So I give that example. The best thing to do is to get the letters early and send them in. The biggest issue I see with brokers, I do a lot of these letters and help them craft these, is that they do it at the closing table and they screw the whole closing up because it's too late to get everything adjusted. So my recommendation is as soon as you're past inspections, as soon as you know you're closing and you're probably not going to have more credits, if you're going to do some sort of commission rebate, do the letter at that time. Why would a broker credit commission? I don't know if you want to go back to like the other slide.
Sure.
And I'm sorry, something on my computer is dinging. So if you guys hear it, I apologize. I don't know how to shut it off. I've spent the first 10 minutes trying to figure it out. Okay. Okay, for what purpose? So why you would want to do a commission rebate. Here's some examples that you may have run into before. One may be that the inspection, something comes up in the inspection report that causes the buyer to maybe want to walk from the deal. You start negotiating it with the seller is willing to put in X amount or lower the purchase price by a certain amount, but you're not getting to the finish line. Sometimes agents will say, I'll cut my commission a little. Both will agree to cut their commission a little, and that's how you make up the difference. So that it comes up in that context. The other context it comes up in, I see a lot, is personal deals. If someone is buying a home for themselves or their daughter or their son, they don't want to collect commission from their family member. That happens a lot. The third way is some people use this as some sort of marketing tool. They'll say they'll help you, they'll give you some of the credit back. I don't want to say, I think it was Redfin. One of the big guys has an entire program kind of built around this idea of crediting commission, but it's used as a marketing tool. What I caution you against is that if you're going to do some sort of program where you're always going to credit them something, I have a client that credits them an amount equal to certain types of purchases. So like, for example, exercise equipment is 1 month. So they credit the amount of what a treadmill would cost. And then you could either buy the treadmill or you could just credit the amount of the treadmill, things like that. It's very fun to do, but you have to make sure you do those types of programs in a few ways. One is that when you're advertising them clearly, and you're doing it in a way that you're going to be able to comply with what you've put out into the world. So if you offer $1,000 of commission credit, and then the commission is only $5,000 and that's not what you intended, you can't pull that back because you've advertised that. So if there's conditions, if you only want to do a commission credit when you receive, say, X amount in commission. So if you're only going to do a commission credit if the total commission is 10,000, say example, or something like that, then you have to make sure you put those, when you're advertising it, you're very clear on what terms you're going to do the commission credit. The other pitfall I see is some folks want to do commission credits only to certain classes of buyers. For example, I've seen someone who says, I'm just going to credit to teachers. That might be okay. Maybe you just want to have a teacher type credit program, but remember you're subject to fair housing. So however you do these programs and however you implement them, you're always going to be subject to fair housing. So you need to do them in a way that doesn't make that where you're not inadvertently maybe violating some other type of rule. So those are some things to keep in mind. But advertising, we're our first, is it our first one in January, Erin? Is advertising, right?
I'm not sure. I think so.
Okay.
I'm not sure.
Okay, we're finalizing the schedule for next year, but
I think you're right.
I think our first topic is advertising. And we're going to get into some nitty gritty because advertising can get super complicated because you have to follow the rules in the state of Florida that require, outside of Chapter 475, that require you to not do any type of misleading advertising or make any fraudulent misrepresentations. So to summarize, if you want to offer some sort of commission credit to a customer, you may do so as long as you're advertising in a way that's not violating other types of laws. You do it clearly so it doesn't run into any issues. You do the credit upfront, I would say, as early as possible to make sure it arrives on the closing agent's desk in time to process it. And to make sure that you notify all parties interested in the transaction, including the lender or the title company.
All right,
and
so I have
the buyer
some
seller.
scenarios.
Okay, go ahead.
So Kristen, let's say buyer and seller are under contract, and like your scenario, let's say there's just a little bit of discrepancy in inspection issues, and let's say buyer's agent, real estate agent, not the broker yet, because we haven't talked to the broker, but buyer's agent says, okay, you know what, I will chip in a portion of my compensation to my buyer. credit towards closing costs. How does buyer's agent get that information, and what piece of paper? You said a broker letter?
Broker authorization letter is what I call it.
Okay.
I don't know. There's broker authorization, like standard forms that sometimes brokers use if the agent's supposed to be paid at the closing table. I don't know how much that's happening these days. I know closing agents tend to not want to do accounting for the brokers. But it's a broker authorization letter in some form or fashion. What it includes, it's not super complicated. It includes the broker's name, the customer's name, the property, the transaction at issue, and then it states, I usually reference the rule that allows it, and then it states how much the credit is and to what party to the transaction it's going to. Typically, I see brokers crediting their own customers, but that doesn't always happen. Sometimes both brokers are crediting, the seller. Both brokers are crediting the buyer just because of whatever issue has come up in the transaction that's being accomplished by this rebate.
So let's say I've got a buyer who, between the buyer and the seller, they're requesting $500 from the seller because this is something. The seller's going to provide the $500 credit, but that doesn't quite get them across the finish line. Buyer hopes also that their own agent will provide them a credit of $500. The concern that I have and I see is that that discussion happens at the 11th hour on the 15th day of the due diligence period. And the buyer, of course, wants to know for sure that they're going to be receiving, of course, not only the credit between the buyer and the seller, but also from the agent. And what it's tempting for them to do is include the broker credit language in that addendum to contract when we still know that the broker is not a party to that sales contract. So I guess the leading question, but what would you recommend in that situation?
So if a customer wants to be protected, if they've been offered a credit of some sort and they want to make sure they get that credit at closing, I will say I really don't see customers get too worried about it. But that's not necessarily a good thing. But the proper way to account for it is either on the listing agreement, or if you're representing the seller and the concession is coming from under the terms of that commission, or the buyer agreement if the commission is coming from the terms of that commission. So depending on what side or what side of the commission payment it's coming from, then you would do it on the buyer side, or you would do it on the seller or the seller document. So the listing agreement typically, or commission agreement, and the buyer broker agreement or commission agreement. And you would just do a modification to the underlying agreement. And then typically what I recommend to brokers is that if you're going to do a modification, especially if it's on the on the sell side or the buy side, it comes up. If you're going to offer a concession like $1,000 rebate or something like that, be very specific when you do the modification to your commission agreement, your listing agreement, your buyer broker agreement, that it's specific to that transaction. If it is only a credit because of that transaction, make sure it's specific to that transaction, because if the deal falls south and a buyer's buying another property or a seller's entering into a new transaction with another buyer, you don't want to be on the hook to credit in that transaction per se. Maybe you are, maybe that's what you've agreed to, but if it's only specific to that transaction, then when you do that amendment to the commission agreement, you need to be specific that it's only for, a credit on the transaction involving seller A, seller B, expected closing on X day, then we'll do a credit of this. This credit won't apply to other closings.
I like it. So you mentioned two things. One is the broker letter, letting everybody, the parties to the transaction, the interested parties, know that there's going to be a credit of some sort. The other part is the amendment to the underlying agreement. So there are amendments to listing agreements between the broker and the listing agent, for example, or between the broker and between the broker.
So I really don't
between the broker and the buyer.
Yeah, and I really don't see customers ask for that a lot. It's best practices to always get any type of change of compensation agreement in writing. But I will say I don't see customers usually. I think it's because it all happens so quickly that they don't typically ask for it to be incorporated into the underlying broker agreement.
Okay. So let's say we've got a sales transaction that buyer's broker is willing to chip in something, listing broker not affected whatsoever, seller not affected whatsoever. They're just happy the deal's moving forward. And then this broker letter is circulated, presumably by the buyer's agent, putting the parties on notice, hey, I'm giving a credit, that. Did you foresee a seller seeing that notice of a reduced compensation to the buyer's broker and saying, well, wait a minute, I think my broker should also provide me a credit? Does that happen? Does anybody get that?
Yeah. I mean, I think especially now because we're operating in a new world, that you could see, I think you're just going to see more negotiation in every element of the transaction. But tools like this help you. Like, you've always got, this in your back pocket if you're trying to negotiate something, or if you're trying to negotiate purchase price and things like that. It all comes together. You can't kind of look at each one as a silo. So I do think sellers might ask why, but maybe sometimes they don't care. I don't really know. I don't know that, I can't think of a specific example where a seller has completely objected to a buyer commission credit. I can't think of an example. I'm sure there's one though. I'm sure it's happened.
Sure, and just to remind our friends in real estate that a seller can't unilaterally make a change to a listing agreement. Neither could a broker. A fully executed listing agreement, neither could a broker make a unilateral change, just as a sales contract cannot be modified until both parties sign. My assumption is that most listing agreements have that type of quality that neither party can just willy-nilly make a change, but they actually would have to get both parties to agree to it. So even if a seller raises a bit of an issue with the buyer getting a credit, and all of a sudden the seller is having to doesn't receive a credit from their broker, that compensation agreement, the listing agreement, cannot just be changed just because the seller gets upset. Okay, all right, so I do want to open it up for some discussion and ask the question. Sometimes when I do sales presentations on sales contracts and we talk about inspection issues, I'm very cautious about suggesting, the mere suggestion, that a broker give up any portion of their compensation to get a deal across the finish line. I will tee up the question and say, what else could we possibly do? And inevitably an agent will say, well, if it's just a minor thing, I will offer to pay for it. I will pay for the repairs. I will offer, a credit for my compensation. And it's usually more palatable if an agent suggests it rather than me as an attorney saying, I'm trying to give away their commission. But as a business decision, it sometimes makes sense to give up a little something for the deal to get across the finish line. So I've had, agents fight over, let's say, $100 nothing. And presumably the broker compensation is significantly higher than $100. And you may be able to purchase some goodwill from the customer. You're getting the deal across the finish line. You're getting parties to be happy and move forward to closing, which of course was the goal that everyone had at the beginning of the transaction. But I have had some agents really push back and say, there's no how am I going to give up a single cent of my compensation on this transaction. I would rather let the deal die. So what do we say? Because we've both been on either side of a real estate transaction that maybe turns a little bit south. So what do we say to get that deal across the finish line? Or when is it appropriate for a broker, let's say the agent's not necessarily willing to offer the compensation, but ultimately it's the broker's decision to whether they want to offer a credit or not? Like, when would that be appropriate? And is it inappropriate for a buyer to make that request of their agent?
I think buyers and sellers can always request anything they want, even if but it's up to the buyer it's up to the broker whether or not to authorize it. If you have a written agreement, specifically if you're working with a buyer and you have a written buyer broker agreement that says what you're going to be compensated, you have no obligation to change that. And then it becomes a business decision as to whether you are going to. And there's situations where it might make sense to do a credit of some sort. If you think you're going to have a lot of business from this person in the future, like you said, the goodwill, then that's something that you want to do. Now, if there was an actual mistake by an agent or a broker in connection with the transaction, and I've seen this in, certain pieces of property, personal property included in a transaction. It wasn't really drafted right. Things got confused. It wasn't advertised on the MLS right. There's some sort of kitchen table that it's not clear from the documents who was supposed to get the kitchen table, and there's a dispute. Buyer and seller both think they're supposed to get the kitchen table. In that circumstance, if there was some sort of wrongdoing on the part of the agent, then you might want to chip in and take care of the table. But generally speaking, if you have your contract, you know what you're supposed to be paid, then that's what you should be paid. Anything beyond that is a business call based on the circumstances of the transaction.
Sure. Yeah, and I say the same thing to listing agents as well. I say, your time is valuable. You have, you've got multiple open houses to get this property under contract. If you let this buyer go over a minor issue,
minuscule,
then you're going to be, relisting the property. You're going to have an upset seller anyways. You're going to relist the property. You're going to, need to continue to market the property. Your seller is going to still have to address this minor issue because it's going to come up again. So many times it makes sense from a business standpoint, but also from just a time management standpoint. Do you have, all of those weekends that you're spending to do another open house for this property that you already had under contract? You could be listing other properties, you could be showing other properties and working with different customers. So I have some fantastic agents that I've worked with, and they never let a minor issue derail a deal. It make a business decision. They say, listen, I've invested X amount of time and money and resources into this transaction. It makes sense for me to get this minor issue out of the way to move forward to closing. And then on the opposite end of the spectrum, I've seen some brokers say, absolutely not. I've earned every single penny of this transaction. I'd rather let this deal die and then have to go back with this, put this property back in the market and hope we get the same purchase price or higher, or hope, the seller's willing to deal with them. Similarly for a buyer, I've had a buyer's agent who said, you know what, I'm not going to budge. Now, what'll be interesting is if buyers agents do not have buyer broker agreements and they have this situation where the deal doesn't go forward and their buyer's upset because they too feel like the transaction could have moved forward if folks are willing to budge a little bit. If you don't have a buyer broker agreement between the buyer and that agent and this particular deal falls apart, if the buyer's really upset, they're going to go find another realtor to work with. So that's another plug for buyer broker agreement between parties, but also for being reasonable when dealing with our credit. So I thought I had that question in the screen, so when this is great. Does anybody have any questions on the chat? Any issues dealing with credit? Any consumer and struggle?
Feel free to ask questions. No questions. Who's going to give Christmas gifts in the amount of credits or commission credits? I'm just kidding. It might be good to go over. So we've got some topics that we're thinking about for next year. We're going to redo buyer broker agreement class. That's a little bit of a moving target because everything changes by the minute. But we will definitely do a case law update, including covering the Florida case sometime next year. We are also looking to do an advertising class in January, and then a second class on branding with a guest speaker to get you guys up and running for the new year and new goals and all that fun stuff. And then we've got a bunch of other fun topics, and we're going to hopefully do a legislative update at some point. What else am I missing?
We'll do personal property pitfalls. So dealing, I like for folks to keep the main thing. So we focus on real estate, but inevitably personal property issues arise. So we can talk about how to handle personal property, especially if you're dealing with a finance transaction. Like you mentioned, we'll do the buyer broker mastermind. It probably makes sense to do that in April because we probably won't know anything from the sister lawsuit until after mid-March. And then the legislative recap, and also we'll do one on the condo and HOA disclosures because that is still the number one way a buyer is able to get out of a sales contract here in Florida if they fail to receive the appropriate HOA disclosure or condo rider or condominium documents. And then we'll talk about what we anticipate happening as far as changes to those condo riders post Surfside and going into 2025. I can't believe I just said 2025 out loud. That's just
I know.
But first things first. So, but if you guys do have any topics that you'd like to hear about, let us know and we'll put it on the calendar.
Yeah.
Oh, we want to talk about the broker discussion too?
Yeah.
So we're planning also hosting some sort of broker open question and answers on, it'll be on, so our classes are on the Tuesdays, but it'll be on the Thursdays of typically the same week that we think coast get paid. So it'll be more of an open forum, but really to allow brokers to hop in and ask questions and discuss some issues that are coming up from a brokerage perspective. So we'll start that in January as well.
Yes, and thank you all for joining us in our first few classes as we have not been super tech savvy and we've been learning each time. So we appreciate your patience with us. Luckily, we've managed to record 3 out of the 4 classes. We only didn't record the first one, so we are coming a long way. The YouTube channel is now up and running. So anything you want to rewatch or things like that is going to be up on YouTube, and at some point we'll figure out how to post slides and things like that, but in the meantime we're circulating them to you all after each session. So we thank you so much for joining us on our first few classes and for your patience with us.
And we'll see you next time. We'll see you in January. So our first class is the second Tuesday of January. I'm going to tell you what day that is. That is January 9th. Get close, get paid. We'll see you then.
Okay,
guys.
Thank
Have
you.
a good day.
Okay, bye.